good evening, good morning, good afternoon, wherever you may be. Welcome to our webinar on international arbitration. I happen to be in Boston right now. Jihe's in Seattle. Cesar is in Madrid, correct, Cesar?
Yeah.
And Arthur is in Beijing, and I'm not even going to ask what time it is for them because it'll make me feel too bad. But we set this up at a time where we were hoping we could draw people from all over the world, and I am happy to say that we did. We actually have far more people from outside the United States than inside the United States here today. We have attendees from North, South, and Central America, from Australia, from Asia, from Africa, from Europe, from the Middle East. I'm no geographer, but that sounds like we have people from pretty much everywhere but Antarctica. So with that, let me start by introducing the panelists. My name is Dan Harris, and I will be moderating today. I have experience in arbitration, and my goal today will be to try to channel what the audience wants to hear from the three panelists. So let's talk now about the three panelists. I will go through the bios of each of them very briefly, starting with Arthur Chu. I actually know Arthur because he and I were on the opposite side of a very, very hard-fought arbitration matter, and he was on my side on that, and we were able to settle it, and I remain so impressed with Arthur that we now work together on matters instead of on the opposite side, although we'd probably be willing to work on the opposite side as well. That's how we lawyers are. So Arthur began his legal career in the United States, but he is now based in China with the Cyan law firm. Arthur is recognized as a distinguished lawyer by Legal 500 and various other international legal associations. Arthur has successfully represented and advised clients in ICC, AAA, HKIAC, that's for Hong Kong, SAI and SIAC arbitrations, and he is also a certified arbitrator for various Chinese arbitration centers, including the SCIA, the XAAC, and the LAC. And he also was recently appointed as an international expert advisor for the China Academy of Arbitration Law. And after reading that, it should go without saying that Arthur is completely fluent in both English and Chinese. And Arthur will today be focusing on current developments in China arbitration and how to effectively manage China-related arbitration matters. Our second panelist today is Cesar Garcia de Quevedo, and Cesar heads up the arbitration practice at Monterrey Mayer Abogados, which is a Spain law firm now, well, Spain-Portugal law firm with offices in Madrid, Barcelona, Palma de Mallorca, and Lisbon, Portugal. Cesar is a member of the Spanish Arbitration Club, the European Latin American Arbitration Association, l'Union des Avocats Européens, and the Deutsche Institute, and I saved this one for last because I do not speak German, but the Deutsche Institute für Scheidgerechtigkeit. Cesar's laughing. He does speak German. Cesar is actually fluent in Spanish, German, and English, and he has arbitrated cases in all three of these languages. And today, Cesar will be focusing on Spain's arbitration system and how Spain is becoming a center for arbitration between American and Latin American companies. And that is definitely something that we have been seeing as well and often like. The third panelist today is Jihe An. Jihe heads up Harris Bricken's dispute resolution practice, mostly representing companies with international or domestic business and IP disputes. Jihe was recently chosen by Law 360 as one of only 5 top attorneys under 40 in international arbitration, and she has consistently been recognized by Thomson Reuters as a business litigation super lawyer. Jihe will today be giving us an overview of arbitration procedures in the United States and talking about some of the trends she's been seeing with respect to arbitration in the past few years. And I am now going to turn over everything to Jihe, and the rest of us will go silent and blank.
Thank you, Dan, for the introduction, and thank you everyone for tuning in. I'm really hopeful that this webinar will be, informative and helpful, and just kind of establish, what we're seeing in our respective regions and how things are looking moving forward. So, as Dan mentioned, I'm going to spend a little bit of time just laying the groundwork for the webinar and talking about, what arbitration is and what it generally looks like in the United States. And I imagine that, it's not going to be too different for other countries, but, obviously I'll let my colleagues talk about their respective regions. So I generally like to loosely define arbitration as a private trial in contrast to a public one. So instead of going to a courthouse and having your case heard by a judge, the parties will agree on having an arbitrator make a decision about their dispute after receiving evidence and hearing arguments. Ultimately, there is usually a hearing where attorneys will make their opening statements, present evidence, and examine witnesses. So in that sense, it's still very similar to, a court case in the US, but compared to traditional lawsuits and trials, arbitration is usually less formal than a court case and a little more flexible in procedure, and, ideally can be completed much more quickly than a court case. To give a sense of, how long things are taking in a busy courthouse like Los Angeles or New York, currently it's really hard to get a case, from start to finish in less than 2 years. Right now we're seeing timelines that are closer to 3 to 4 years. And so arbitration has definitely become more popular for our clients, and I think it's going to continue to get more and more popular as people become more familiar with it. So now getting into the timeline of things, the first step in the arbitration process actually takes place long before any arbitration begins. And that is because the first step is the drafting of the arbitration clause that is going to be included in your contract. Arbitration is not something you can force the other side into. Either the parties have agreed in the beginning of their business relationship or in the beginning of their transaction that they are going to arbitrate any dispute that may come up, or, on the flip side, when the parties have come to the realization that some form of dispute resolution is necessary, they are going to agree that arbitration is what they want to do. Most large arbitration forums in the US, like the American Arbitration Association or AAA, they actually have very standardized forms to initiate the arbitration. And that form requires the claimant or the person who's initiating to affirmatively represent that the parties indeed have a contract that provides for arbitration under the AAA rules, or the parties have to affirmatively indicate that they have agreed to arbitrate under the AAA rules. If the claimant is not able to, make that affirmative statement, then they're going to have to establish that the arbitration forum has jurisdiction over the other party in some other way. So going back to the arbitration clause, I want to spend just a minute talking about why tailoring it to your specific business relationship or transaction can be really important. Arbitration, like I said, is getting really popular on a global scale, I believe, because it allows for more flexibility and procedure. And if you do that right, it can take less time and less money to complete. So at the outset, when you're drafting that dispute resolution clause, I think it's really important to do things like identify the number of arbitrators that you would want, because, that can make a big difference in ultimately how expensive and how thorough the arbitration is going to be. On one hand, I have had cases where one arbitrator makes sense because the issues are not too complicated and, it really is limited to one specific area of law or one issue of law. But I've had other cases where it does make sense to invest in like a 3 arbitrator panel because, the dispute might be really complex. It might require expertise in several areas of the law. And then you have a chance to make sure that your panel really is equipped with the different areas of expertise that might be required. Another consideration for the arbitration clause is, thinking about what the best forum or location for your potential arbitration is. And I know that we have gotten questions about that, and I believe Dan is planning on, kind of posing that question to all of us later in the webinar. But here in the US, there are really great kind of national services like the AAA. JAMS is another one that have rosters of extremely reputable arbitrators. And even in the international context, AAA has an international division called the International Center for Dispute Resolution, or ICDR, that we've used on several occasions, and that's very excellent too. So those are just some very basic considerations that should be taken into account when you're drafting your arbitration clause. And, if there are others, it's really good to discuss those types of issues with your attorneys, at the very beginning when you're drafting your complaint, so that you know what to expect if a dispute comes up down the line. So fast forwarding now, let's say that a dispute has come up and the arbitration clause that you drafted is now coming into play. The next step in the process is initiating or responding to the arbitration claim. That's very typical. Sometimes we counsel clients to prepare a 1-page claim just to get the arbitration initiated. Sometimes we counsel clients to prepare, the full-blown document of facts and claims to get everything started. It really depends on what the strategy is. And then obviously the defendant or the respondent will have a chance to prepare their, defense and any counterclaims if they have them. After the initial filings are sorted, then sometimes the parties will pick their arbitrator while the initial filings are sorted. But, around that time, the parties will work together to pick their arbitrator or panel of arbitrators. And one thing that I've definitely been noticing in the US is just a diversification of arbitrator pools from which the parties can pick, because, issues are becoming more and more complex. Issues are becoming global issues since parties of different countries are doing business together. So even many of the US forums have really been working towards pulling arbitrator candidates from other countries or pulling candidates who have really niche experience and knowledge, like intellectual property and patent disputes and that kind of thing. Once the procedural aspects are kind of sorted out, the arbitrator will set up a general timeline for the case that typically here ranges, I would say, from about 9 to 12 months. And in that time, discovery and motion practice is going to be conducted, obviously to the extent that discovery devices like depositions or document requests or even expert discovery can be limited. The parties can choose to do that. So in the arbitration that I had early last year, we limited the number of depositions to, one key witness for each side who had the best understanding of the facts. We limited expert depositions to a certain time. And we did things like that just to streamline the process, because a lot of times, parties and lawyers can get really bogged down in the kind of minutia of the case that ultimately isn't pertinent to the overall claim that has to be made. So, we typically like to embrace that. And then finally, all of this kind of culminates into a hearing where each side presents their case, their witnesses, their documents. And then after the hearing is over, the parties will typically prepare a closing brief that will kind of outline their best arguments, the best pieces of testimony from the hearing, and provide them to the arbitrator for final consideration. The arbitrator will then issue an award, and some awards are, very bare bones. They'll just kind of announce the decision, and others, give a reasoned award that kind of outlines the whole thought process. So that's kind of my spiel about how the arbitration process works in the US. And now I guess I'll turn it over to Dan to introduce our next panelist.
Thank you, Jihi. And it's going to be Arthur who is up next. And one thing I should have mentioned at the very beginning, we did ask people to give us questions beforehand, but you are also able, and we encourage you to pose questions during the event, because there's going to be plenty of time for answering questions at the end. And you just go to the questions tab and ask your question, and we will do our best to answer it. And Arthur, if you could please come on here, I will turn it over to you to talk about arbitration in China.
Okay, great. Hi, Dan. Thank you, everybody. And I'm happy to be with you, even though it is a little bit early in the morning. But it's a great, I'm glad for any opportunity to be able to explain aspects of China arbitration to those who are curious or need to know, because they're dealing with these kinds of legal matters. And I'm honored to be with such a distinguished panel. One aspect, while it's I'm thinking of it, is in terms of what Jihi had talked about in the procedures and the formation of an arbitration in your dispute. The model clause, the model arbitration clause in your contract, which is always recommended for the institution, the arbitration institution that you ultimately end up choosing, will give that information. If you utilize the model clause, it will, of the institution, it will help you validate your to make sure your arbitration clause is validated to mitigate risk of issues with your arbitration proceeding or arbitration award there forward. And every institution in China, such as CTEC, the National Arbitration, and the major ones of Beijing and Shenzhen and Shanghai, all have published their model clause indicating the parties' agreement to enter into arbitration. and to utilize a certain commission or institution as their arbitral seat. So I'm here today to talk about China arbitration relating specifically to foreign matters or foreign disputes in commercial in commercial settings. I want to dispel some of the falsehoods or unknown aspects, which can be scary and can make you feel hesitant or concerned about coming into China arbitration. And I'll bring up some of the background facts and data for you to consider in that regard. The first arbitration institution is CTAC, China's International Economic Trade Arbitration Commission, which is headquartered in Beijing, but has 8 representative offices all over China. It was established in 1956. China ratified the New York Convention in 1987, and the National Arbitration Law of China became effective in 1995. As you can tell by the dates, China's establishment of a standardized arbitration practice has been comparatively newer than other countries, but it's accelerated at a tremendous pace for the reasons of China wanting to catch up and also to put itself, in a similar level with other institutions and with other practice, because of the globalized and necessary position for not only Chinese companies doing outward bound ODI, but also foreign companies coming into China. They recognize the need for a legitimate and valid dispute mechanism. So China did create a strong arbitration system. The current structure now, as I mentioned, there's CTAC, but also in addition to CTAC, there's over 250 provincial, municipal, city arbitration centers or arbitration institutions or commissions. Right now as of 2021, the favored venue globally was Beijing, which was tied for New York at 6th place. Shanghai was 8th place globally as the favored venue. The favored seat, CTAC, the National Arbitration institution, was chosen 5th behind ICC and London and Shanghai, but it was tied for 5th as the most chosen global arbitration institution. Currently, as of 2021, CTAC has 483 foreign arbitrators, non-Chinese arbitrators, on their panel list of arbitrators you can choose from 85 different countries. So you don't have to choose, and other Chinese arbitration institutions also have their own list of foreign arbitrators who have qualifications in specific areas of law, and of course the language abilities to deal with foreign related matters. And in 2022, just last year, the top 4 China arbitration institutions, CTAC, Shenzhen, Beijing, Shanghai, had over 1,200 foreign related cases, and those cases related to over 100 billion in dispute value. As I mentioned, arbitration is a focus and a priority as a dispute resolution mechanism for China. So the development in the last 5 years have grown and have expanded to further provide arbitration services and support. So there are now, in the last 5 years, there are specialized institutions dealing with very specialized subject matter. Shanghai, for example, has an International Dispute Resolution Center and other centers now that offers multiple ADR services relating to mediation, dispute prevention, and of course arbitration. There are specialized law focus institutions for arbitration, such as Maritime, CMAC, and investment, ASEAN and APEC related investment, arbitration, etc. And there has been measures taken by the People's Supreme Court for integration and support of arbitration. So local courts have created special divisions to hear challenges or review when it is appropriate, limited challenges and review, which is generally allowed by arbitration law in China and follows other countries' position. But the key aspect is that they wanted to pinpoint and highlight the importance of it, so they created special division to ensure that that the matters heard and is heard by the qualified individuals. And there's also a China International Commercial Court, which is a division of the Special People's Court, Supreme People's Court, to set up for interim measures, enforcement of international arbitration cases. There's a lot of foreign cooperation in the last 5 years. Foreign cooperation such as other arbitration institutions setting up representative offices in China, such as ICC, such as WIPO, WIPO, and Singapore Arbitration Commission. They have set up offices, and legal organizations such as FIDIC for the England Construction Model Law has set up offices here to continue to educate and promote the international style contracts and structure of management of dispute. There are arbitration support organizations such as CAAL, which I am a member of as an expert advisor, the China Arbitration Academy for Law, and there are other organizations that do training that disseminate information relating to the latest topics of how arbitration, international arbitration matters. And all of these aspects of development and support means that the bodies and the people that are related to arbitration in China are receiving more and more education, more and more training, and more practice experience, which only can lead to better facilitation in China of those matters. So I think at this point, I just wanted to share that with you, some specific data points to show where China is at currently in the arbitration area. And I think I'll be able to talk more in more specific detail when we come to the next part. Thank you.
Thank you, Arthur. I have one comment on what Arthur talked about, and I think it might be helpful because my perspective is as an American lawyer. In our law firm, there have been many times where we have wanted a CTAC or a Beijing arbitration clause in the contracts for our American clients. And where that most often happens is in a manufacturing agreement where we think the odds are much greater that our client is going to sue a Chinese manufacturer for giving them bad product or being late with product than any other sort of dispute. And the advantage to the dispute being resolved in arbitration in China is that it can move faster, and it's also more likely to be enforced by the courts there. And Arthur also raised the point that you get to choose your arbitrators. And until this person retired, we actually chose a specific arbitrator as the chairperson, and the Chinese companies would usually agree. He was a law professor, very highly regarded, Canadian, not even US, and fluent in Chinese. And so don't rule it out. And in some cases, you can't rule it out because a lot, in fact, nearly all Chinese state-owned entities now require arbitration be in China before a Chinese arbitral panel. Okay, so moving on now to Cesar to enlighten us regarding Spain, arbitration in Spain. Thank you. Hi, Cesar.
Hi. Hi, thank you, Dan, and thank you, dear panelists, too. It's an honor to join you in this webinar. I wanted just to describe you the situation of arbitration in Spain, and I want just to begin with a short introduction about the origins of the actual regulation of arbitration in Spain. We've got a lot of historical precedents that back then to Roman law, but obviously the important development of arbitration in Spain begins in the 20th century, especially in the international perspective of the arbitration, because this is the one that matters. I would say this is essential for the arbitration, the international aspect. And with this regard, Spain ratified in 1961 the European Convention on International Commercial Arbitration, and in 1977 the Convention on the Recognition and Enforcement of Foreign Arbitral Awards made in New York on June 10th, 1958. But Spain needed two more relevant events to fully join the international arbitration community, at least in my opinion, and one, namely our accession to the European Union, which happened in 1986, which triggered our presence in international trade and thereby favored the approval of our actual Arbitration Act, number 16 from December 2003. This Arbitration Act was adopted, the UNICITRAL model law on arbitration. And as you well know, this model law is extraordinarily relevant on an international scale because it establishes a subtle compromise between the continental European and Anglo-Saxon legal traditions. And then I wanted just to point out certain aspects of the Spanish Arbitration Act. Many are very similar to what already Jihi told us, because the proceedings are more or less very similar. And obviously the Spanish regulation acts only as a supplement provisions in case the parties don't regulate anything regarding their arbitration, which is, let me say, a very strange situation, because nowadays, as for instance Arthur explained, and obviously also Jihi, it is the most common arbitration is nowadays the institutional one. In pure theory, it is possible an ad hoc arbitration, but usually the parties tend to choose an institution, because choosing an institution gives you a guarantee of, in a certain way, a predictability of the outcome, a security, and obviously the parties need that kind of security nowadays, and they demand it, especially in international businesses. But with regards to the Spanish regulation, just allow me just a few comments. Obviously, the necessity that the arbitral agreement is in writing with the express will of the parties to submit to arbitration. Peculiarity in Spain is in case this agreement obviously obliges the party to comply with the agreement. and prevents the courts from hearing disputes on matter relating or submitted to arbitral proceedings. But what happens when the counterparty doesn't oblige this agreement? Well, in Spain, in case you get a claim from the counterparty, you have only 10 days to submit an objection to jurisdiction. So you have to take into account that kind of peculiarities that sometimes happen, because in case you have been notified and this time of period expires, then you are out of the arbitration agreement. And another peculiar thing is the uneven number of the arbitrators that the parties may choose. And then I'll skip to the timing, because I think that's relevant. I share what he told, that nowadays the arbitrations are not as speedy as they should be. But from a legal perspective, in Spain, the arbitrator has to publish, to deliver the award in 6 months of the date of the submission of the statement of defense or the expiry of the submission deadline. This 6 months period could be extended for 2 months, but eventually the parties could opt out for this option. But obviously, the problem with arbitration and the losing of time and so on happens at the beginning, at the nominating of the arbitrators and so on. But strictly speaking, if you see the Arbitration Act, you see as a wonderful timing just to get such a decision in such a short time. The award can be global or can be partial. That's also a possibility. And eventually this partial award could be subject of enforcement separated from the global award. And another peculiarity would be, for instance, with regards to the American system, the obtaining of evidence, because the institution of the discovery is not known in Spain. Obviously, you can ask to the judicial court to the counterparty to provide certain documents, but it's very, very limited. So you have to take it into account if you have an arbitration in Spain. Another thing that could be relevant to mention would be, for instance, the possibility of setting aside the award, which is extraordinarily relevant. It's very restricted. We follow here, our law follows the model law. I won't get into details, but it's pretty clear and is subject to a very strict interpretation through the judicial court that it's competent to know about these things. It's the superior court of the autonomous region where the arbitration takes place in Spain. And obviously, I have to mention the two very relevant decisions of the Constitutional Court that happened in the years 2020 and 2021, which definitely, in my opinion, represent the respectful vision of the arbitration, because since those judgments, the decision of the arbitrators in this award can't be subject of any revision, just only in very extreme cases, just formally. The surrounding, let's say so, the surrounding of the arbitration procedure, but nothing more. The judges won't get into the decision of the judge. And just to give you a peculiarity also from the Spanish Arbitration Act is that employment arbitration is not admitted, and also is not admitted in the activities of the public administration. But it is thought that, and it would be good to expand this possibility of ADR to those fields because they are got a lot of problems nowadays, and it would be a good decision to increase the pace of the judicial proceedings, because in Spain we've got a problem with the judicial courts. We've got a lot of amount of work, and the cases we lose a lot of time going to the judicial courts, and therefore arbitration is always a good decision. And lastly, I wanted to inform you about a new court we have in Madrid, recently established in Madrid, and it is the Madrid International Arbitration Center, which began its activity in 1st January 2020, and it administers international arbitration proceedings in 4 languages: in Spanish, Portuguese, English, and French. It depends from the Madrid International Arbitration Association, and it is the result of the merge of the most relevant arbitration courts of Madrid: the Madrid Court of Arbitration, the Civil and Commercial Court of Arbitration, and the Spanish Court of Arbitration. And it is to mention that this Madrid Bar Association is also an active member and a strategic partner of this association. This court wants to focus in the election of Madrid as the seat of arbitration, especially Spain and especially Madrid, because they tend to focus on the relationships between Europe and America. Obviously, the culture, the language, the shared values, the same legal tradition that we share with the whole America, and obviously the quality of the legal operators in Spain, attorneys, experts, and the competitive cost, obviously, compared to other arbitrational seats. And as I said, also obviously the Spanish judicial system that is clearly pro-arbitration. So regarding the rules, just a short comment on that before I finish. They are very similar to the ones that has the ICC, but with significant differences. For instance, the Madrid International Arbitration Center has the possibility of the early determination of the claim, which is a possibility that recognizes the London Court of International Arbitration, but the ICC doesn't, at least so clearly. It's possible an interpretation of the rules, but it's not regulated as clear as in this new court, as I said. So summing up, we think that compared to America or China, obviously, Spain is not such a big seat in international arbitration, but we think that Spain should be considered seriously as a seat, as choice for those types of conflict, obviously towards America with other European countries, but why not between a conflict between China and America? And thank you very much for your time.
Thank you, Cesar. And now we will turn to the questions that we've gotten and been getting from our audience. I'm just going to say one thing to Cesar, which is that we are definitely seeing and liking contracts that call for arbitration between U.S. and Mexican companies, U.S. and other Latin American companies being resolved in Madrid. That seems to be the trend. Okay, so with that, what better question to turn to than one that we got many times before this event and even at least one time during this event. People seem to want to know what arbitral body they should use. So I'm going to ask each of you that question, but because you're lawyers, I'm going to say you can only list 2. I don't want you to list 5 or 6, 2. So starting with you, Jihi, because you're on the top of my screen here, what 1 or 2 arbitral bodies in the United States would you recommend that foreign companies use if they're dealing with an American or some other company or a company from some other country?
Yeah, that's a good question. I think I'm a big fan of AAA. AAA is obviously one of the biggest forums, and like I mentioned, they have their own international division, the ICDR, that I think has a good grasp and is able to, it's set out a procedure and rules that typically everyone can follow. It's very clear. And then the roster of arbitrators is obviously excellent. I know a lot of the arbitrators in the US are retired judges and things like that. And so you get a sense of a very formal proceeding, which I think some clients like. So, if that's what you're looking for, I think AAA is great. But also, I'm located in Portland, Oregon for most of the year, and we have a small regional service called the Arbitration Service of Portland. And that is, I find it's equally excellent, even for international disputes. For me, it really comes down to the arbitrator that you pick, because they're going to make a lot of the decisions about procedure and what they care about, what they want to know about your case. So I either say go really big, go with the formal institution, or check out your regional institution too.
Okay. And I'm now going to turn to Arthur, but I'm going to get a little more specific, because one of the questions said, will you please address what arbitration is now recommended in Chinese cities like Shenzhen, Shanghai, Beijing? And then the person says, and I actually know this person and he's a fine lawyer, says CTAC no longer. Now, I don't know what he means by CTAC no longer. So Arthur, is there something now wrong with CTAC? What arbitral bodies would you recommend?
Okay. Well, thank you, Dan. Yeah, you threw that one out of left field there. And I don't know. It's tough for me to say exactly what they're referring to. Certainly there's no in the legal community or industry in China and in Beijing, where I'm situated, and where the CTAC headquarters is, there's no specific red flag or in relation to CTAC.
Okay.
Many years ago, there was a jurisdiction clarification that needed to be made because of CTAC's seat and being Beijing, and that was resolved through the subcommission of Shenzhen and Shanghai. So CTAC subcommission spun off into independent local body, local seats of Shenzhen and Shenzhen arbitration and Shanghai arbitration, where they used to be a part of CTAC, but that was causing some confusion in relation to the jurisdiction of CTAC, but that's been since resolved. From my experience, and I work with lawyers who are arbitrators in different. I am an arbitrator in China, and I work with different arbitrators as lawyers. So we talk a lot about these aspects, and CTAC still, to me, in terms of an institution, a center to deal with foreign related matters, structurally has the most established position. Their rules are very formulated. They follow not all aspects, but some of the major aspects follow the UNCITRAL model laws. So they're familiar. CTAC follows the IBA rules of procedure. So it's more, people in the arbitration fields consider IBA rules more akin to common law versus the Prague rules of evidence, which would be more civil law related. So CTAC is very loosely put. CTAC follows international institution rules and laws. Some are not exactly the same, but they follow the same parameters, and also in relation to common law. BAC would be my second choice, Beijing Arbitration Commission. The reasons why I also would choose those is because Cesar touched on it, Jihi touched on it, is that the institution itself is the foundation for your arbitration dispute, but it's only the foundation. The key parts to your structure is what you can choose, what you will choose with your counsel strategically, who you choose to be your arbitrator, and what specific rules of procedure do you agree to. That will take more impact and influence on how your proceedings go and the potential outcome, because the institutions only provide the guidelines and the frame and the administration, but who makes the decisions, who manages, who proceeds, handles the proceedings to make sure that everyone's heard fairly is the arbitrators themselves. And CTAC has by far the most foreign arbitrators listed, and CTAC also allows, and BAC also allows arbitrators outside of the panels of the list that they have. So if the parties designate or pick someone outside of CTAC, they are allowed to do so as well. There's other reasons, but I'll leave it. I'll let the other guests speak too as well.
Okay, Cesar, what about in Spain?
Well, surely the one I've mentioned, the Madrid International Arbitration Center, obvious. Okay. And I would choose the ICC, because you could choose this an institution and make the seat in Spain too. Obviously, you can choose the seat wherever you want, and it usually gives the clients a lot of guarantee. The track record of that institution, the possibility of the scrutiny of the award, for instance, which it doesn't enter in the decision, okay, but in the form of the decision. And as I said, obviously, another point very interesting is the expedite procedure, for instance, that eventually can go on without hearings. So I would say I would choose between both of them.
Okay, excellent. And Arthur, the person who asked the question about China, has written and said that he sent it on his cell phone, but you nailed the answer. So you gave the answers he was looking for.
I appreciate that. And one other thing, I'm as I breathe a sigh of relief. I think this is all applies to all three of us as well in our different, institutions or discussion of arbitration institutions and whatnot. But there's a practical aspect as well. There's, CTAC as the largest has a strong budget for their facilities. They have a strong online data support system. They have, China has created what's called the intelligence system, I believe, which means that it's kind of a one-stop shop where they've created their institution to make it as simple as possible, including online data submissions, on and on, so on and so forth. So, so the ease and convenience, the facilities, the top-notch facilities, resource centers, training. CTAC provides a lot year-round training for their arbitrators and year-round information resources. These kind of things help from a practical standpoint. And CTAC is also in Beijing, which is the capital, but it's very centrally located. And it's where, frankly, it's a city where top lawyers and top people in the legal profession come to. So CTAC has very strong, qualified professionals. Not to say that other Chinese institutions don't; they do. But CTAC certainly is a leader in that aspect as well. So the practical considerations, logistical, practical, as well as the other things we've mentioned.
Right. We've had a number of cases in CTAC, and I've always found it very easy to understand the rules and to deal with the administrative personnel at CTAC. Okay, so here's an interesting question. It says some languages such as Arabic do not have a separate set of terminology for arbitration to distinguish it from judicial proceedings. Do the presenters find particular problems with translation for arbitration? And I'm going to mention something that has not come up, and that is that American companies tend to assume that their arbitration everywhere in the world is going to be in English. I remember one time a company came to us for a Korean arbitration, and I said, you know, we're going to need to bring in a Korean lawyer. And this person had signed, this company, and not a small company, had signed a contract calling for arbitration in Korea, just assuming it would be in English. And so not only should you use the model clause, which Arthur talked about, which is, and I think G touched on it as well, you should put in the language of that arbitration. And I have heard, and I don't really care whether it's true or not, because the rules should be you put in the language. But I've heard that generally in Latin America, the language of the arbitration will be the language of the contract, which makes sense to me. But in most of Asia, I think the language of the arbitration is wherever you are. So that's something you should be specific with. Now, turning to the question, do you find problems with translations for arbitration? Feel free to jump in, any of you.
Yeah, I can tell you I had horrible experiences in a cross-examination with an interpretation between German and Spanish. It was completely horrible. I had to intervene. I had to say to the translator that that's not what this person is saying. Mm-hmm. And it was a good professional, but everyone can make mistakes, no? But in those cases, it would be better not to assume those risks.
Yeah. Yeah, I think the only thing, I mean, I agree with what Cesar is saying, and I would just add that sometimes, you know, we've made the decision to appoint kind of a key witness for our side who does have, you know, who can speak better English or speak better whatever the language is, so that we're not having to deal with that problem with every single person who might have information. And I think that's a way to sidestep it. But in general, if you're going to have different languages, you know, you're going to just have to engage translators, and things might get more expensive just from a cost perspective to combat that problem. So yeah, definitely a big consideration.
Yeah, and
no, go ahead.
Just to kind of pile on or add to that, I mean, we're all international lawyers. Most, you know, our cases go all over the world, so language is going to be, you know, multilingual, and it's not just the language of the arbitration, but it's the whole process. It starts, you know, having clear language from the contract to the negotiations to the contract, and then in disputes, and then in enforcement. You know, for example, of a consideration is that even if you do everything in English, but you have to enforce in the Chinese courts will need the translation of the materials and documents and of the award. So in every step of the way, there has to be, you know, strong, consistent, contextual, not just literal translation, but also contextual. And it's so important whether, I think you can choose, you know, English or Chinese or Spanish, or whatever language. But what's important is that, you know, you have the language that you choose, you have very proficient native contextual translation. Otherwise, it's just going to create a world of problems where it didn't need to be. It's not a legal problem. It turned out to be a translation problem, but it causes legal problems for you.
Yeah.
Okay, we're going to have to wrap up now. It is, well, where I am at 7 p.m. Thank you, everybody, for attending. Thank you, Cesar, Arthur, and Jihi, for a terrific job here today. If anyone has any additional questions, and I suspect there are some because there are so many that we did not get to, feel free to email us, and we'll probably, the three panelists will likely answer some additional questions in a blog post somewhere, which will alert you to the questions that didn't get answered. So again, thank you, everybody, and good night or good afternoon or whatever. So long.